Good afternoon, everyone. We have gathered here to celebrate the 12th Annual International Conference titled 74th Constitution Day, also known as the Law Day, which is hosted by the Indian National Bar Association. We would now be starting with the next panel, the topic of which is online litigation and arbitration, online versus offline. The moderator for this panel is Mr. Tanwani, General Manager, Legal, Cummins India Limited. The speakers for this panel are Mr. Navdeep Dahiya, Senior Associate, Advani Law Firm, Mr. Vivek Kapoor, Barrister and Arbitrator, 39 Essex Chambers, London, Mr. Chirag Balyan, Assistant Professor, MNLU, and Mr. Susheel, President and GC, Atlantic Gulf and Pacific Company. We welcome you all. A huge round of applause for this panel.
Hello. Good afternoon, everyone. I welcome you all to this session. This is a very relevant topic, and we have the right people on the panel as well. So thank you for the introduction, but still I will just introduce everyone for the sake of understanding. So we have Mr. Chirag Balyan, who's the professor at National Law University, Mumbai, and he's also the center head for the arbitration in the National Law School at Mumbai. We also have Mr. Susheel. He's currently the General Counsel and President at ACP India Private Limited. It's one of the largest gas distributor in India. And we also have on the right Mr. Vivek Kapoor. He is the partner and barrister at Essex Chambers, London. He's also the counsel who's supporting India. Hello. Yeah, so he also supports India, Singapore, and London for his practice. So we welcome you all, and we also have Navdeep, who is from Advani and Law. He's also an arbitrator and barrister, and he's based out of Mumbai, but he also works all across India as well. So I welcome you all, and I'll start my discussion with the corporate first, and then I'll go to the practicing, and then finally I'll come to the academic part of it. So, Susheel, welcome to the panel, and I wanted to understand, as a general counsel and a corporate lawyer, how have your experience been on the online and offline litigation / arbitration, and what do you think, what are the pros and cons from a very corporate standpoint? Over to you.
Yeah, thank you, Love, and thank you everybody and the organizers for having us here. It's a great platform to share our experiences and hear from the top leaders in the industry, top legal brains, that what's happening and what are the solutions to some of the problems. So it's a great platform to begin with. Thank you very much. See, to begin with, I'll answer this question that today technology is in the every sphere of life. Your IT, your technology is progressing so fast that legal profession, be it any administration of justice by the Supreme Court, High Court, lower courts, it can't escape this reality of life. We have seen in the COVID times that the courts tried and successfully tried the online hearings, which was a great success at the time when the justice had totally come to halt. Taking cue from there, seeing the success of the online hearings and the justice to quick justice to the needy, this concept has definitely gone a long way, and now you can see all the virtual courts happening in the Supreme Court, almost all high courts. Even the Supreme Court has given now directive to all tribunals to go online. So this is definitely a step forward because there will be greater access to justice. Today, what is happening that somebody in the remote area, he wants to challenge something in Supreme Court. He doesn't have the resources, he doesn't want to travel, he doesn't have that sort of, to hire an expensive lawyer in Delhi. Today he can easily hire a counsel in a remote area, in a district area, and get his case argued all over the country, anywhere. So it reduces the cost, it reduces the, the trouble of coming all the way, And it's a speedy justice which can happen for a needy person who cannot afford justice in higher courts, which is very expensive these days. So it reduces the time. Secondly, it has become a very good boon for the lawyers. If somebody sitting here can argue in 10 high courts in a day, he doesn't have to travel. So your travel cost has substantially reduced. So your cost of litigation has reduced. Like we sometimes prefer to file our petition in Delhi High Court, though we had the concurrent jurisdiction in some other high courts. We used to say we'll save our cost because we'll travel every time to Chennai or Jodhpur or some other place. Now you can hire a lawyer from Delhi and he can argue online in his high courts, no need to go. So this has been a really a very good step, and now even you see most of the challan courts, lower courts, challan courts, they're all already online, no need to go. But having said so, there are some challenges, like when you have to get some stay, or in first hearing you want to get a stay, you won't like to have an online hearing, because it's something you want to be there. For regular hearings, yes, we do prefer online hearing when there is a formal hearing, we know adjournment is going to come, time is going to be given for filing replies. But for the getting an interim orders, we have to be there. Second, when you have to cross-examine a witness in the lower court, then it's not practically possible to have the online cross or examination of witness. That thing happens in arbitration also. Because in arbitration also, there's a lot of, something may happen during the cross of the witness, secrecy may not be maintained, somebody may, guide the witness behind the camera. So these are all practical problems which they are facing. I think now what we practically see, it will be blend of both. For some hearings, we will prefer to be online, but for final hearing, as well as for getting interim orders, it will be definitely, you have to be physically present in the courts. And secondly, one drawback in the online hearing definitely is that the attention span of judges on online hearing is very less. You can't gauge what judge is thinking on online hearing. You have to, when you're appearing in person, you see the judge's mood, how he's thinking, how I should calibrate my arguments, whether I need to something put more. On the online hearing, that drawback is there. You can't gauge what judge is thinking. That is one negative point. Second, when we argue online, offline in the courts, very senior lawyers, eminent lawyers, there are so many youngsters like you who are sitting in the, or young lawyers who are sitting in the courts. They learn by seeing those judges arguing, how articulate they are, where to pitch, how to argue, how to, put your case. So in the online hearing, there's the biggest drawback that the learning process for youngsters who are in the courts, that is missing. So this is some of the aspects. So I think it's good in a way, but both will exist because there are practical problems where both of the online as well as offline will go a long way.
Thank you, Susheel, for sharing great views, and I completely agree because even I am an in-house counsel and I have faced that issues. And now moving on to a different aspect from a counsel to actually a practicing arbitrator. So Vivek, I wanted to understand that what are your thoughts on the same question which I asked Susheel, and I wanted to also understand that you being in cross jurisdiction as well, how your experience have been and what also the client's preference has been. Over to you.
Thank you so much, Love. I'm going to take three aspects of my, or rather four aspects of my practice. The London High Court, how was online hearing played there, international arbitration, the Indian High Courts, especially Bombay High Court, where I've done quite a lot during COVID, and sitting as an arbitrator. And getting a slightly different perspective where you're not the counsel arguing, somebody's arguing and trying to convince you. I think one of the biggest advantages that has come out of COVID, I think this is sort of, it was terrible on a human level, but I think in terms of the legal profession, one of the good things that happened was the use of technology. That technology always existed. In arbitrations, in hearings, every once in a while we would use VC, but it was never the norm. That changed, which was, from a client perspective, very helpful, because for procedural hearings, suddenly you didn't need to fly counsel, you didn't need to fly teams, you didn't need to fly in-house counsel for a 3-hour hearing, spend a lot of money. So clients started preferring that. As counsel and as well as arbitrators, the reason that was being preferred is suddenly all you have to do is switch on your camera, spend 3 hours, and you're done with that case. You don't need to travel there. You don't need to get acclimatized. You know, I live in London. If you're going to Singapore, you need to go 1 day in advance. You need to be very careful. You have to get the adequate rest so that when you start the case, you know, you're very sharp. That significantly changed. And that was one of the biggest advantages that came out, because I think one of the big complaints that users like you have for us is litigation and arbitration, especially internationally, is becoming very expensive. You know, friends like you say, look, you're in the business of disputes. My company tells me we are not in the business of disputes. So we don't want our spend to keep going high on ancillaries, 10 people staying in a 5-star hotel, 10 people taking an international flight. Your time being spent monitoring everybody to ensure that, you know, that the process is run well. So the introduction of virtual hearings was very good in that respect.